Welcome to our webinar for Queensland Justice of Peace and Commissions for Declarations. In this session, we're joined by colleagues from the Department of Resources and Mines who will discuss the National Mortgage Form witnessing requirements. We hope you enjoy this webinar and find it useful.
And hello and welcome. This is Brendan from the JP branch. We are very lucky to have with us today two officers from the Department of Natural Resources and Mines, Miles and Carolise. They'll be running us through some of the interesting topics around the new National Mortgage Form and other topics. We'll be answering questions today. Probably we might answer the questions towards the end, because as you might know, generally if you ask a question, sometimes it's answered in the next slide. If we do see something pertinent though, we'll jump on it and answer it. If we don't get time by the end of today's webinar to answer all of your questions, we'll email you an answer. So everybody that sends through a question that hasn't been answered will receive an email. I'm going to hand it over to Miles and Carolise now. And thanks again for everyone for joining us this morning.
Okay, just a general thing why we're here today. One of the reasons is not only to discuss the National Mortgage Form, but just to give a bit of refresher on why the National Mortgage Form is treated a bit differently to any other forms you may need to witness. Now, I know it's a boring topic, but legislation is the overriding reason that the National Mortgage Form is treated differently. In particular, the old favourite, Section 162 of the Land Title Act, and just it puts mandatory requirements on you. And by mandatory, I mean the legislation uses the word must. So it's not a may or a should, but it's a must. So it's a very strong requirement. So that legislation talks about four things. One, you must take reasonable steps to ensure the signatory is entitled to sign. Secondly, the person must sign the form in your presence. Thirdly, the witness must not be a party to the transaction. And lastly, you need to print your name because that is part of the prescribed form. Now, we'll just briefly touch on some of those requirements through the presentation before specifically discussing the National Mortgage Form. So, reasonable steps are steps that an ordinary person would consider prudent and fair in the circumstances. Basically, using your common sense and your intuition to make sure that you are satisfied the person sitting in front of you is the person who they say they are and that they have a legitimate part in the document. Okay, so that first of all, proving their true legal identity. And that most commonly is through some sort of government issued card, passports, driver's license. I've accepted a Queensland government identity card. I understand that shooting licenses also have photographic identifying, and they're also government issued. So that's being fair if they don't all have driver's license. The reason why we are fairly strong on the identity is transfers and mortgages are the biggest target for fraud, and so that's why we want to make sure that you're not participating in someone losing their very valuable asset. Okay, so evidence which associates a person with the content of the document, that's usually a contract of sale or a loan document. There may be other forms you will accept as well. That's being fair in the circumstances. Okay. So proof of identity. I've talked about being from government issued. I would be very hesitant to accept anything from a non-official source such as a university ID card. They can be whipped up in 30 seconds on a colour printer. So government issued takes a little bit longer and is a little bit more certified. Okay, another common question that we get asked with a multicultural society we live in is, what if the documents aren't in English? Okay, so best practice from a registry perspective, if you can't read the language of the document, it needs to be translated by a qualified person. And that person is usually from NATI, the National Accreditation Authority for Translators and Interpreters. That may delay the process if they haven't got that already, but it's better to be safe and know what evidence they are presenting than having a guess. But as I said on the screen there, the key is that you are satisfied with the evidence presented to you, that they are the person sitting in front of you, and to record that information in your logbook, please. Next. Okay, another modern age question is dealing with electronic copies of documents. So being a good public servant, there's a yes and a no answer to this question. So yes, you can accept downloaded copies of documents as proof of ownership if they are not to be lodged with that document in our office. By that, I mean you can accept electronic copies of rates notices, contracts, loan documents, because they don't come into our office. The no part to the question is if they are to be then included with the form, whether that be a certificate of death, a trust deed, then you need to cite the paper copy as supporting evidence. Okay, so one of the big questions that the legislation is focusing on is the entitlement of the person sitting in front of you to enter into that transaction. The registry takes as broad a view as possible on this question, purely because we know how important people's homes are to people, and we want to make sure that they feel as secure as possible, that they aren't, the registry's safe and isn't participating in any fraud. So the other modern day scourge is like abuse of elderly people, people from non-English speaking backgrounds, or people with mental disabilities who may unfortunately be taken advantage of. So part of your role in helping prevent this abuse is to focus on this entitlement to enter into the transaction in a very broad sense. And that means asking questions, whether upfront, in-your-face questions, or more softer, indirect questions as to do they understand what they're signing. A direct question could be, oh, so I see you're selling your house. Have you found somewhere new already? Or another indirect question, oh yeah, are you going for a bit of a tree change or a sea change? Plants the idea in, hey, might be not be owning this house at the end of this process. The same goes with if your translator's been brought along, remember to include their details as well. Doesn't have to be a formal translator, it could be a friend or a family member who's translating on their behalf, but their details should be put into your logbook as well. The last stop point can be very delicate to handle, but if your radar goes off and you have somebody sitting in front of you and they've got a son or a daughter there just saying, sign it, mum, just sign it. We've got other things to do today. Or someone telling you, you're just here to sign the document, don't ask any questions. That's a bit of a radar going off. There could be some an underlying ill intent to the transaction. If they get overbearing, just ask them, hey, I just need to talk to your mother, your father alone, just to make sure they understand. Could you just step away for a couple of minutes? Easier said than done, I know, but it may help the person open up to say, yes, I don't understand what I'm doing. And in that case, decline to witness and say, you might wish to go to independent legal advice. And that way you may have saved them from signing a mortgage they didn't understand. Okay, so this is the old mortgage form. As you can see, it's sort of had everything on the face of the form. So now I'll just hand over to Miles, and he can take you through to the new form.
All right, good day, guys. So yeah, we're just going to run through the national mortgage form. It's not too much different from the old one, so it's fairly simple, but we'll just go through the main changes. So the main purpose of the National Mortgage Form is standardising the content presentation of mortgages lodged for all registration through all lodgement channels with land registries in all Australian states and territories. So basically, you can lodge this form in any titles registry in Australia. So the form commenced 29th of May last year and is now the mandatory mortgage form as of the 2nd of March. So the previous mortgage form will only be able to be used after the 1st of March 2018, provided one of the parties signed before this date. So we still are receiving some of the old mortgage forms, and we will do for a while till they all get lodged. But anyone preparing a new mortgage form obviously will have to prepare on the National Mortgage Form. On our website, best way to find the form is to just Google Titles Registry Forms and then click on the first link. And when you scroll down, you'll see it there. It'll be, I'll just bring it up. Yeah, so National Mortgage Form will show there. And there's two versions. There's the online form and just the Word form. So the Word form basically is just, you're just filling out the document as you normally would, like you do with the old mortgage form. The online form is a sort of a new thing. So you're obviously utilising technology now. You actually answer questions on the website and it generates the form for you, and then you print it out and then you can sign it. There's various ways you can do it, and we'll go into that in a second. I'll just show you real quickly where you can find these forms just in case. All right, so this is our website, and this is the forms page. So when you scroll down, you'll see the National Mortgage Form is here and the two links. And I'll just show you real quickly what this new form looks like, the online version. So you click on Web Form. And this is obviously really important. So when you're starting a new National Mortgage Form, you got to select which state you're going to lodge the document. And basically then from there, you just fill out the relevant details. Most importantly, mortgagor, mortgagee. So if you click on, this one's individual currently, so yeah, that's fairly basic. Corporations, it changes the execution panel on the form depending on who's going to be signing it. Same for mortgagee. And there's also this option. So who will be signing? The mortgagee themselves, under a power of attorney, solicitor, legal practitioner. So if you choose that, again, then it asks you more questions. So it's fairly easy and basic to do.
So that's why each National Mortgage Form you see may be slightly different, because they've chosen different options when they've completed the form. The old Form 2 didn't have any options like that, so that's why, no National Mortgage Form will probably look alike when it comes to you for witnessing.
And we still have the typical, just the Word version of the form as well. Let's see if that loads up. Yeah, so that's, again, we recommend using the electronic generated version. It's just simpler. This one will ask all the questions. So it's going to give you every type of capacity you can sign in, every option. So it's a bit more complicated to use. Many solicitors use that one. All right. Okay. All right, so going on, the National Mortgage Form can be completed electronically and printed out for manual processing. So that's what you'll get. Can be completed on paper, manual witnessing and lodged over the counter. If we can complete, and then the last two options, obviously completed electronically, e-lodgement, that's what solicitors use, and completed. paperless through PEXA, which is the online service. So you won't see those two. If the form is being completed electronically, the format alters according to what information is selected. So the biggest thing we're going to push with this is just making sure if you receive a form that's been filled out by someone, make sure it's Queensland as the jurisdiction on the form. If it isn't, they're going to have to obviously print another one out. The biggest thing, the layout of the form looks different, but its contents and witnessing requirements remain the same as the current mortgage form. So a few minor changes. There's no item numbers. So down the left-hand side of the page, you get items sort of 1 to 6. They don't list there anymore. There's just headings. Each national mortgage form is a minimum of 2 pages. It's never going to be 1 page anymore. And the terms of the mortgage is now embedded into the form. So there's not usually an attached form so much. It's now in the document itself. So this is a fully completed national mortgage form. I'll just run through it quickly. So the jurisdiction, that's a big thing we pull out, Queensland. As you can see, lot and plan, that's all the same. Heartland affected, we'll get to that in a second. Mortgagor, mortgagee, all pretty basic. Here are the terms of the mortgage. So this schedule, or it used to be on a Form 20 schedule, but now it's just very simple. It's just embedded into the document. Nothing you need to worry about too much. The biggest thing here is just the execution panel. So good point now is you've got more room. You don't have to squash it in there. You can fit your stamps there a bit better. It's spaced out. You've got all the parties there. It's a lot clearer. And same with the mortgagee's execution. Again, most of the time this is going to be the bank, but you do get some mortgages that have been lended through family members. So you may be witnessing mortgagee's executions as well. Obviously this one here is done under a power of attorney, so no witnessing. So steps for witnessing. Ensure the jurisdiction, reads Queensland. For multi-lot titles, there will be a Y under part land affected. So basically, this is the new thing on the form that wasn't there before. Basically, most of the time you're going to see it's going to be blank, and that's simple. That just means it's just one lot number over one title reference. If there is a yes there, we just recommend confirm with the client that only one lot is being dealt with in this mortgage. So basically, this question is asking, there's actually 2 lots on one title, and they're only selling one of those lots. So that's why they've put a yes in that box.
Yeah, while Queensland generally has only 1 lot per title, a lot of the other states still have multi-lots where a title might be lots 1 and 2 on SP 1, 2, 3, 4, 5, 6. So Queensland is trying to get away from that and go 1 lot, 1 title. So that's why, because it's a national form, we still have to have that question in there.
So unlike the old Form 2 mortgage, all information is on 1 page in most instances. Obviously, this is now on 2 pages, the national mortgage form. So to ensure your witnessing obligations are met, we sort of recommend putting down the first and second page side by side and just comparing them. These are the things we recommend comparing. So check the mortgagors and mortgagees' names are correctly shown on the relevant panels. Check the execution panel is appropriate. So they would have selected the correct person, an individual or power of attorney. So a mortgagor is to sign personally, but they've selected an attorney to sign. Check the reference number shown on the bottom of the page is consistent on all pages and the page numbering. So as you can see, there's a reference number on the bottom left of the forms. That'll be on every single page, and the page numbering matches up. So if I just go back real quickly, so you'd confirm the mortgagors on the front page to the second page. So Hayley Marie Tucker, Bradley Stewart Sullivan, yep, that's all good. Mortgagor, Commonwealth Bank, yep, that's all good. Reference number down the bottom left, and the page numbering. So those 3 things, you just have a quick breeze over to make sure they match up. Different types of executions you're going to see. So obviously a company execution, they don't require a witness, but you'll see them. And power of attorney executions. So again, they're a lot clearer now. You've got all the headings there, and they just fill in the relevant panels, what their position is, the power of attorney number. It's fairly simple.
Okay, so this chat here is a little bit about On the old mortgage form, item 2, where they used to show the lot and plan, was always a bit of a problem at times. Okay, if the item 2 was left completely blank, we would say and support you in declining to witness that form, because how can you prove their entitlement to sign that document and they own it if there's no information about the property there at all? So this, so that's just a recap on if the same rules apply for a national mortgage form. If the panel which asks the lot and plan description is left completely blank, still decline to witness it and refer them back to their lawyer or their bank to complete the details there, because that is not your role to research and find that information. Try and keep up with the modern age, we have introduced a bit of flexibility into the system though. And sort of most of you will be familiar, well, hopefully you may have seen this form before. It prints out with mortgages and transfers. I know that solicitors and banks have a habit of discarding it and not providing it to their clients, but it is, as I said, automatically generated. Now, if you note in part 2, the last stop points there gives you a few options for supporting documentation. In particular, the last dot point there, which says a letter from a solicitor confirming you are entitled to sign the form. That option there is very handy for when we're doing what we call off-the-plan purchases, where the client knows, buys a block of land or a unit off the plan, yet the plan hasn't been registered in our department yet. So they know part of the real property description, they just don't know the title reference. So and because developments are happening more and more frequently and developers are asking for the money sooner rather than later, the flexibility that we allow in the system is that solicitor's letters. So Titles Registry best practice is recommended that you can accept the letter if the letter covers these requirements. Should be on solicitor's letterhead, be signed by the solicitor and not a paralegal or a secretary. That's due to insurance and indemnity issues. The letter should refer to at least the lot on plan and that it is an off-the-plan purchase. If there's just a street address in there, then Miles in a few seconds will go through how you can convert a street address to a lot on plan. The letter should also cover that the plan's not yet registered. And then if it covers all of that, then you may wish to consider accepting a partially complete real property description with no title reference. That letter should probably be retained by you just to help you with your records. Okay, so they might also actually produce a copy of the survey plan to come with you. So in this instance, the client may come onto you and say, look, I know I'm buying lot 1880 on this plan, and they've marked it on the plan, so you would just be able to confirm that information has been filled out in the national mortgage form. And if there's a solicitor's letter accompanying it, quoting that lot 1880 on SP 205113, then that would be good supporting evidence as well.
Yeah, so this survey plan won't have been registered with us yet, so we have no knowledge of it. It's just been prepared by the surveyor, so it hasn't got to us yet. So they can't do a title search because it doesn't exist as yet. But this does prove it's been prepared. The purchaser knows what block they're buying and the dimensions of it and all that stuff. They're happy to go ahead with it and sign the transfer document on mortgages. So you will get instances where they don't have a lot on plan description or title reference, and they've just got a street address. So there's two sort of methods we can sort of recommend. The first one here is better. I'd say it's a bit easier. This is the method to ordering a title search from our website directly. But as a part of that process, it will show you the lot and plan description and title reference for free. You don't have to order anything. And the second one is through the Queensland Globe. So if you just follow these steps that we've got listed here, you should be able to pull it up pretty easily. But I'll just show you how quick it is to do it. All right. So this is, I'll just go back. So this is the screen. Once you follow the steps and you get to the screen, actually I can just show you from the start. Well, basically it's just simple as typing in the street address. It'll load it up and you just click on it. And then it brings it up on a map. And then from there, it tells you the lot and plan description. If you need to know the title reference as well, again, if they haven't completed this on the form, this is a way that the client can find it. Then it tells you the title reference just there and your lot and plan. So if for some reason they wanted to go ahead and order a title search as well, they wanted to know who the owner of the property is, they can do that from here.
Obviously, this only works for registered lots. It won't work for off the plan because, as Miles just said, we don't have that information recorded in our database yet. But if you do have a client and it's a pre-existing property, this is one way that they may be able to fill out that part of the form without having to go back to the lawyer or the bank. And it's this is drawn from our database, so it's accurate information. Okay, another problem that you may come up across when dealing with a mortgage or even a transfer is lack of supporting evidence. No contract or agreements are sometimes put into effect if it's a gift between spouses or transferred for natural love and affection from a parent to a child or something like that. So how do you go about proving their entitlement to sign there? There are two recommended methods up there that are that previous JPs have shown and told us about, which if you're comfortable with, are very workable. The first one is that the person gifting the land or lending the money just provides a statutory declaration stating it is their intent to lend money to so-and-so for a mortgage on this property. So that way they're not being pressured into it and it is a legitimate transaction. As it says up there, if you do use this method, please keep the statutory declaration as part of your records. That way you've got a bit of evidence that, yes, you did do your due diligence in making sure that they understood the nature and intent of what they were signing. Another way is if they don't have a contract, but the parents may have gone to a real estate agent or a bank just to talk about the processes involved and get perhaps a valuation. Have a look through that, and if the correspondence mentions the property there and the intention of the parent to gift the land to the child or a spouse wanting to transfer the land to his new partner, that may also once again indicate there is a legitimate intention for the transaction and would be perfectly acceptable. That's not a comprehensive list, and we just remind you that as long as you are satisfied and comfortable that your witnessing obligations have been met, it can be fair and flexible and record the information in your logbook. Previously, we mentioned the logbook and recording information in that would include, in terms of a mortgage, the current owner of the land, the borrower who's lending the money, the property description, the real property description, and whether you saw a contract or other supporting evidence. In terms of the identity part of it, you would note Queensland driver's licence or passport. You don't record the actual number of the passport or the driver's licence, just you saw Queensland passport, Australian passport or Queensland driver's license. So what evidence, photographic ID you did see. So that's the kind of information you record in your logbook. Okay, another issue that has been cropping up from time to time is what if information on a form is wrong? How do you go about fixing it? Our office has categorised incorrect information on a form in two ways. One is an amendment and the second is an alteration. Amendments are basically typos. Now, you spell "and" with an E instead of no E. You've typed, in terms of a plan number, you've typed SP instead of an RP. So the intent of the document isn't compromised and doesn't alter in any way if there's just basically a typographical error, which is what we call a minor correction. These corrections can be just initialed by the parties to the form. Witnessing officers don't necessarily have to witness that. Where witnessing officers do need to get involved if there is an alteration. And by alteration, we mean something that changes the outcome and the intent of the form. That could be adding a complete new title reference into the form. It can be adding or deleting a middle name of somebody. It can be changing the tenancy from a sole proprietor to a trustee. All of those change the outcome of the form and impact upon your witnessing obligations in terms of, okay, proving their entitlement that they owned this additional property, that, okay, what proof of identity did they have that they now have to remove a name or even add a name to a form. If that's the case, then you need to initial that alteration as well. So just to make sure that, yeah, you recognise that the form was incorrectly completed and you're part of updating the records. Okay, if an alteration occurs, a Form 20 will need to come in with our office. Witnessing officers should not be filling this out because this form is filled out by the parties involved in the transaction, not by the witnessing officer, but they may have one there with you, and that's just an example of what they may present to you. You shouldn't be filling it out. Okay, so if you've got any questions, our office is more than happy to receive emails or phone calls about it. But we've, because this is the end of our formal presentation, what we'll do now is run through the polling questions. There are a few more polling questions, and then we'll go back and look at some of the online questions you've been putting through. Okay, so we'll just give you a few minutes to do there's 4 questions, and then we'll come back and answer a few of the online stuff.
We're having some issues with one of the polls. We might try and go back to them, but in the meantime, I'll read out a few of the questions and we'll ask Carolise and Miles to answer them. So we've got a question from Katrina, and she's asking whether it's a requirement that we stamp the forms. It was my understanding as well that in the past we didn't put a stamp on the forms, but there's plenty of room in the new National Mortgage Form. Is stamping a requirement or a necessity?
It's still not a mandatory requirement to affix your stamp for a National Mortgage Form, but as Brendan pointed out, there's a lot more room on the National Mortgage Form. So if you feel more comfortable affixing your stamp, please go ahead, as long as it doesn't cover up any information such as name or execution date. So yeah, but as I said, there's still not a mandatory requirement to affix your seal.
Okay. Katrina's also asked about witnessing a mortgage form for New South Wales, and apparently when we do that, there's no requirement for a JP to witness those forms. So she's asking whether they're witnessing it as a JP or as a private individual.
I'm not, unfortunately, too familiar with New South Wales mortgages, but if I would just read the form and see what the the form says about who can be a witness. It's strange that they wouldn't have somebody a little bit more qualified and wouldn't have someone qualified to witness. So I'd probably just investigate that a little bit further, and I can get back to you on that one.
Robert's asked about sending these slides. No, Robert, we won't be actually be sending out these slides to everybody. What we'll be doing in the future is hosting all of these webinars on the JP website. They've all been recorded. In due time, once we put some closed captions on them, we will be hosting them on the website. So people that weren't here today will be able to view the presentation as well. Joseph's asked, what is the duration timeline for a JP to retain copies of evidentiary documents?
That's a very good question. And at the moment, current archival standards for our office are 7 years. I know that's going to be a pain to hold logbooks for 7 years, but our office operates under the state archival system standards, and that's 7 years.
I'll try and relaunch these polls. Oh, excuse me. Lisa Shaw from JP Branch was about to say something.
Joseph, just in relation to the requirement for retaining documents, there isn't anything written in our policies or procedures around that, but can I just let you know that we're working on general retention and disposal schedule for volunteers as well. So just watch this space. It's definitely something that we'll be taking action on.
Yeah, we can just run through the questions anyway. So the first one we had was from the 2nd of March, all mortgages must be executed on the National Mortgage Form, true or false? So the answer is true. So the transitional period for the move from the Form 2 mortgage to the National Mortgage Form ended on Friday the 2nd of March this year. So a Form 2 mortgage will now only be accepted for lodgement when one of the parties has executed the form on or before Friday the 2nd of March. So question number 2, we had a mortgagor or borrower presents you with a National Mortgage Form for witnessing. Do you ask for ID and then witness their signature? Abide by Section 162 of the Land Title Act 94 by witnessing obligations have been met? Or decline to witness the form as I haven't seen it before? Answer B, so your witnessing obligations have not changed under 162 of the Land Title Act. So you must take first reasonable steps to ensure that the individual is entitled to sign, have the individual execute in your presence, and not be a party to the instruments. None of that's changed, basically.
So we've got some more questions coming through. It's Grant. He's asked, what's the policy around witnessing more than one National Mortgage Form?
Oh, that was one of the questions we got here, I think. So, so if you've been asked to execute 2 original National Mortgage Forms by the same party, all requirements under the Section 162 have been met, what do you do? So do you decline to witness it? The second, as there can only be one original mortgage form witnessed, do you witness the National Mortgage Form and ask the client to return with a photocopy so you can certify it as a true copy? Or do you assist the client in witnessing both National Mortgage Forms? Some financial institutions request 2 forms to be lodged. The answer is C, so you can assist a client and witness more than one copy of the Land Registry form, as many as they like, really. Some financial institutions may provide 2 or more copies for you to witness. 1 copy will be lodged with us in the Titles Registry, and 1 will be retained by the bank or financial institution.
Con's asked if he can take a photo of the documents for his records. So Lisa's going to answer that question for Con.
Thanks, Con, for that question. And it is a good answer, a good question based on the fact that we all have a mobile device in our hand at the moment that can take a photo of something. Look, the short answer is no, that we wouldn't recommend that you take photos of any documents. And the new edition of the handbook actually provides information about, what authority do we have. And really, as Justice of the Peace, we don't have any authority to take copies or retain copies of documents. that belong to other people. We would really strongly recommend that you use your logbook, which you can record the name of the parties who are involved, the type of document, the type of identification, not the numbers of identification, and the fact that it was a particular type of land titles. Over on the right-hand side of the current logbooks, there is a comments section, and in there you could write the title reference because that is public record. So that's pretty much all that you need to do. It's storing information electronically is not something that is supported by Justices of the Peace Branch.
Joseph's asked a question about if a JP suspects that somebody is under undue influence or pressure, is there a mechanism to inform anybody about that?
Definitely. The last slide on this presentation had contact details for both the JP branch and the titles registry. We would love to hear from you if you have concerns that there is possible fraudulent activity going on over that title. We have multiple contact methods. We have telephone, email. You can either phone, write into us, if possible, providing us with the title reference and a brief description. I believe that the owner of this property is being pressured in, and Titles Registry has internal mechanisms for monitoring activity on that title. And when activity happens on that title, we pay a little bit closer attention to it.
Okay. So, Joseph, just to clarify, if you were to inform JP Branch, we would just ring the Titles Registry anyway. So maybe save me a phone call, cut out the middleman and go straight to the registry office. Barry's asked, what if a client doesn't have any photo ID? And can we accept a Centrelink pension or health card? Definitely.
If that's being fair and flexible in the circumstances. If you have what we call a suite of other evidence, such as government-issued pension or Centrelink cards, that they've gone through a bit of a vetting process to obviously obtain that. If you have, say, 2 or 3 of those other forms of identification to prove that, yeah, they are a real-life, legitimate person, then I would be comfortable in accepting that, and just note that you accepted Centrelink card in your logbook instead of driver's license.
Wendy's raised the old bugbear of people presenting without supporting documentation. She's wondering, is there anything else that can be done to try and to limit that? Because as we all know, the witnessing officers are kind of caught in the middle. They've got their obligations under 162, and then the clients get agitated. I'm not sure what else can be done from our perspective, but perhaps land titles might have a different view.
Yeah, our office works closely with the Queensland Law Society, and they have a magazine publication called, and we regularly put something called a snippet in there reminding lawyers to pass on that page that's printed out to them. We have mixed success there. We have less success with the financial institutions, with the banks and them, reminding them, because they rotate their staff through the lending side of things on a regular basis. And while one branch may be good 1 week, a month later, when they've got new staff in there, that information may not be passed on. So yeah, we really appreciate that you do get hammered by people not turning up with the required information and you having to say, sorry, can you come back later? We do try, but sometimes it is a lost cause in certain circumstances.
Wendy's also pointed out that she's seeing more requests from financial institutions to fill out a witness certificate, and they won't always accept the one that JP Branch provides to all of our signing sites and other witnessing officers. I think that's more of a comment, but do you have anything to say to that, Carolise or Miles?
If you're comfortable with the other financial institutions' witnessing certificate, then by all means sign that. Just be aware of privacy issues, because some of the other ones ask for your personal information, whereas the JAG one refers all inquiries to this office here, so you are kept anonymous. the JAG one also has an indemnity disclaimer, which has been vetted by the legal section here, and that clearly states that you've only gone through the witnessing of their identity. You haven't gone through any of the other financial requirements in lending money. So that's just a bit of a warning if you do accept another financial institution's request. But ultimately, it is up to you to ask to decide whether you actually sign those witnessing certificates or not. They're not a mandatory part of your role. They're the role of the financial lender to do that.
Okay, so if do you think it might be best practice to see if somebody presents to you to witness their mortgage documents, to ask them if they have a witness certificate? Because I've received a couple of complaints from clients. JPs have witnessed the documents, but then don't go ahead and witness the witness certificate, and it needs to be completed by the same officer. Do you have any comments on that?
Once again, modern age, we try to keep up with that, and a lot of financial institutions aren't bricks and mortar these days. They're all online, so it's hard for a financial institution which doesn't exist in reality or in the real world to go in and have the paperwork filled out in their office. That's why they send the mortgage witnessing certificate out when they're online only. So in that case, being fair and flexible, you may wish to consider the witnessing certificate and signing it at the same time as the mortgage or the transfer.
Okay. Well, I think that pretty much wraps up all of the questions. We've got one more question from Con about taking photographs, but I thought we were fairly clear. We don't recommend that you take any photographs. Oh, excuse me, there's another question that's come through. It's more of a comment than a question. Some feedback. Apparently we've gone a bit too fast for Janice. I apologise, Janice. We did have a lot of material to cover today. It is actually really good feedback though. But as I said, this will be hosted on the website in due course, so you'll be able to take your time when you're rewatching it. Perhaps press pause. I know there's, particularly on some of the slides that Miles was showing about how to do title searches and the instructions. I know we didn't give you a lot of time to copy down that information, but in due course we will be hosting it on the website, so you will be able to get all that information again. Well, like I said, I think that's the end of today's webinar. We hope you enjoyed it. Thank you very much for attending. We've had a really good turnout today. We had 72 people logged on at one stage. Actually, one more coming through. Michael Reese is just saying that he's watching from the Commonwealth Games.
Lucky you.
Good on you, Michael.
Yeah, that's dedication for you.
One more. One lucky last. Oh no, again, that's just thanks, but I'll take that personally. Thank you. You're welcome. Thanks to Carolise and Miles for taking the time. It can be a little bit of pressure doing a webinar with this new technology, but they've handled it very well, and hopefully we can convince them to come back again and do another one in the near future. And
as I said, more than happy to approach the Titles Registry directly to answer any other questions you have, email or phone, or and ask for Miles. All right.
All right, thanks again, and we will see you next time.
Thanks for tuning in. I hope you enjoyed the course, and we look forward to bringing you more online professional development training in the near future. Thank you for your continued work in serving the community of Queensland. We'd love to receive your feedback on this webinar. You can email us at jpsinthecommunity@justice.qld.gov.au.